Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, I love to be able to use real-life examples to teach about self-defense laws, and today we get a local example from right here in Seattle, Washington, an incident that took place a couple weeks ago. Story just broke. All sorts of coverage out there. But it does teach us one of the most important concepts of self-defense laws, one that unfortunately does not get discussed enough, and one that actually lands a lot of people in jail. And in this case, it'll probably be something worse than that. So today, let's spend a few minutes and let's talk about the real-life first aggressor and why he's going to prison. Okay, America, we are going to go all the way down to the Seattle waterfront, not far from where I am at right now, and we're going to show you a rather terrible confrontation, an unnecessary confrontation, and a confrontation that landed one guy in the hospital, the other guy in jail, and he's probably going to prison, and I'll explain why in just a moment. What I'm going to do is I'm going to introduce you first to 32-year-old Gregory William Tim. That's him right there. Now, Mr. Tim is going to be the shooter in this particular case. Mr. Tim has a checkered past, if you would, because he was convicted in 2020 in Jacksonville, Florida, for intentionally driving a van into a tent full of Trump supporters, but I digress. I'm also going to introduce you to 68-year-old Harold James Powell, a person who routinely hangs out at the Seattle waterfront around Pier 55. He is a street musician and is a veteran. Now, according to the probable cause affidavit, Mr. Tim accused Mr. Powell of stolen valor. And while Mr. Powell was retrieving his military ID, Mr. Tim decided that he would take property of Mr. Powell, that being a veteran patch, and not give it back to him until Mr. Powell had produced the appropriate identification, because somehow or another Mr. Tim believed that he now suddenly was the Stolen Valor Police. Now, this led to a situation in which Mr. Powell then charged at Mr. Tim, but understand, Mr. Powell's in a wheelchair. So when I say charged at him, he's coming at him in a wheelchair. And he did pull a knife in defense of his property. Mr. Powell also had an airsoft rifle holstered on his wheelchair. Not sure why, but he did. And yes, by all accounts, the airsoft rifle did resemble a real firearm and also may have been displayed or even pointed at Mr. Tim. That then led to the following confrontation, which I will point out I have edited portions of this video to keep YouTube from completely crapping their pants about it. I will link up, however, in the description box, links so you can see the full video. But without further ado, let's go to the replay.
Show me your ID. Gun on me.
Okay, so this gives us an opportunity to touch on several aspects of self-defense law, including when do we get to use lethal force. We get to use lethal force if we believe that we are in imminent threat of death or serious bodily injury. And if Mr. Tim believed that Mr. Powell actually had presented a real firearm, he would have been in that position. This also gives us the opportunity to discuss that Washington State is a no duty to retreat state, which means you are under no duty to retreat. And certainly, as we can see from the video here, Mr. Tim took that to the nth degree by standing right there, slowly and methodically getting his firearm from his man purse, and then standing there and having ample opportunity to draw on him before discharging the round. And all of that would be worth diving into deeper, having a much deeper geek out session on that if it weren't for the subject of today's video, which of course is the First Aggressor Standard, because Washington State, like most states, has a First Aggressor Standard, which essentially means that if you are the one that provokes the confrontation, if you're the one that picks the fight, you don't get to then later claim self-defense. So when we go back into what the allegations were, it is Mr. Tim who confronted Mr. Powell with an accusation of stolen valor. Mr. Powell, however, is in fact a veteran. Mr. Tim then stole property from Mr. Powell and was essentially saying that he would not return it until Mr. Powell produced sufficient ID, whatever that would have been, to Mr. Tim. Now, while Mr. Powell may have acted in a slightly unreasonable manner by charging at him with a knife in the wheelchair, and certainly exercised terrible judgment by displaying an airsoft rifle, and while certainly Mr. Tim had no duty to retreat, and he clearly took that very seriously, all of that is irrelevant because at the end of the day, it is Mr. Tim who provoked this confrontation. It is Mr. Tim who picked this fight. It is Mr. Tim who then stole property from Mr. Powell. And it is Mr. Tim who then used the lethal force as the first aggressor, or what we like to call in Washington State, assault in the first degree. Now, to give you an idea of what the jury would be instructed if this case goes to trial, WIPIC, Washington Pattern of a Jury Instruction 16.04, would instruct the jury the following. No person may, by any intentional act reasonably likely to provoke a belligerent response, create a necessity for acting in self-defense, and thereupon kill, use, offer, or attempt to use force upon or toward another person. Therefore, if you find beyond a reasonable doubt that the defendant was the aggressor and that the defendant's acts and conduct provoked or commenced the fight, then self-defense is not available as a defense. Words alone are not adequate provocation for the defendant to be the aggressor. So Mr. Tim's accusations of stolen valor, standing alone, probably isn't enough to make him the first aggressor. However, when he willfully stole the property of Mr. Powell and then would not return it until Mr. Powell did the acts that Mr. Tim demanded, which was show him military ID, that is absolutely positively an act of aggression. It most definitely makes him the first aggressor. It most definitely negates any claims of self-defense he has, and in all likelihood would result in him serving a rather long prison sentence. Listen, like I say, we'll go ahead and link up the full video down below so that you guys can see everything for yourself. I am interested to hear what all of you think. Maybe you think we got it wrong. Maybe you think Mr. Tim acted in total lawful justification. Would love to hear what you guys think. Listen, in the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool. You click on that link and you tell us all about it. If you want to subscribe to the monthly newsletter, that information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Well, and just to give people the type of understanding of the financial catastrophic occurrence that occurred, you and I are both privy to people who have been involved in lawful self-defense situations, pulled the trigger with legal justification, faced potential legal consequences, and had to fight for their freedom. Didn't have coverage. How much money did it cost them to win their freedom?
You know, I really don't think that people really can grasp, you know, the magnitude of expenses. You know, most recently, and you and I have talked about this in the past, the Kyle Rittenhouse case brought a lot to light.
Right to bear, that's right. Legal protection for self-protection. Listen, good lawyers aren't cheap. Cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.